In this video, we will give you an overview of the key actors involved in the Australian taxation system and where the tax law comes from. There are four key actors. The first key actor is the Parliament. Under the Australian system of government, all taxation law must have a legislative base to it, and the Parliament is the only body or institution that can make legislation. The second actor is taxpayers and entities. Taxpayers are people that are engaged in economic activity to which the tax law may apply. Taxpayers can be natural persons and artificial persons, for example, companies. Entities refer to partnerships and trusts. The third actor is the Australian Taxation Office, ATO, which is the government regulator. The head of the ATO is called the Commissioner of Taxation, and the Commissioner is required by legislation to administer the taxation law. This means ensuring as many people as possible comply with their legal obligations under the tax law. For example, ensuring that taxpayers fully declare their assessable income accurately and they do not overstate their deductions. The ATO carries out many activities to help achieve its aim of taxpayer compliance. For example, it conducts tax audits and data matching activities. The ATO also publishes a lot of guidance for taxpayers on how it interprets the tax law. We will come back to the topic of interpretation later. The fourth actor is the courts, and to a lesser extent, the Administrative Appeals Tribunal. The strict role of the courts is to interpret the law and resolve disputes between the parties. Often, taxpayers and the ATO are in dispute on how the tax law should apply to a transaction or activity. In resolving disputes, the courts often provide interpretive guidance on the tax legislation. Interpretations adopted are then available to help apply the tax law to other transactions and other taxpayers. In certain areas of a tax law, the courts effectively make the law. Take the example of the most important section in the Income Tax Assessment Act 1997, namely Section 6-5. Section 6-5 only contains 14 words. In summary, it says the ordinary income of a taxpayer is included in her assessable income. Parliament has not provided a definition or guidance on the meaning of ordinary income. Because of this, both taxpayers and the ATO have needed to rely on the courts to fill the gap on the meaning of income. Another example of an area where the courts have effectively made the law can be found in respect to Section 8-1, the General Deduction section. Australia's income tax system is largely a self-assessment system. The same can also be said for Australia's goods and services tax system and Australia's fringe benefits tax system. So, what is meant by a self-assessment tax system? Self-assessment is where taxpayers are responsible for ensuring they comply with the tax law. Broadly, self-assessment works as follows. Taxpayers with sufficient taxable income are legally required to lodge an annual tax return, tax statement, with the ATO. That tax return must disclose their taxable income and therefore their tax payable accurately. Generally, the ATO will accept the information in the tax return as being accurate and will issue a tax assessment based on that information. However, the taxation laws give the ATO rights to conduct audits and reviews and to issue amended assessments to taxpayers. These powers allow the ATO to ensure that taxpayers are stating their taxable income and therefore their tax liability accurately. If taxpayers have been found to understate their tax liability, they will be required to pay the tax shortfall. Depending on how culpable the taxpayer's conduct was, they will very likely be required to pay a penalty for creating the tax shortfall. The Parliament and the ATO, however, understand that because of the complexity of the tax law, sometimes taxpayers find it hard to be accurate about their taxable income without some professional guidance. Accordingly, the Parliament has given the ATO power to issue binding public rulings. These are in addition to the authority that the ATO possesses to write publications, for example on its website, providing guidance to taxpayers. A binding public ruling sets out the ATO's view of the tax law on a certain topic or transaction. These rulings can provide very useful guidance to taxpayers on difficult areas of the tax law. For example, the following binding public rulings are very useful. 1. Taxation Ruling TR 98/9, Self-Education Deduction Expenses. And 2. Taxation Ruling TR 97/23, Repairs to Premises and Depreciating Assets. These binding public rulings are strictly not law. They are the ATO's opinion of the tax law. Remember, the ATO does not make law. However, the Parliament has made public rulings binding on the ATO when the ruling is more favourable than the tax law, legislation and cases, to the taxpayer. In effect, the ruling becomes the law for that taxpayer. On the other hand, when the tax law is more favourable than a public ruling, the tax law will apply to the taxpayer's facts and she will not be bound by the ruling. Unfortunately for taxpayers, binding public rulings are rarely more favourable than the tax law. What is more common is that the ATO makes binding public rulings that are less favourable than the tax law. To further assist taxpayers in complying with the tax law, Parliament has also provided for a binding private ruling system. Briefly, a taxpayer can apply to the ATO for a private binding ruling on how the ATO thinks the tax law applies to the facts contained in the taxpayer's ruling request. If the private ruling issued to the taxpayer is more favourable than the tax law, legislation and cases, the ATO is bound by the ruling made, and the ruling effectively becomes the tax law for that taxpayer. On the other hand, if the private ruling is less favourable than the tax law, the taxpayer is not bound by the ruling. The taxpayer can challenge the ATO view in the courts. From the above, ATO website publications, ATO booklets, etc., although very useful sources of tax information, are not the tax law. This means they should not be cited as an authority in your answer to a tax problem. Subject to the comment below concerning binding public rulings and binding private rulings, the only authorities you should cite in answering a tax problem is the tax legislation and the cases. When a binding public or private ruling is more favourable to a taxpayer, that ruling can be cited.